Good afternoon. I wasn't expecting to be invited at this stage. I thought it'll be a little later. But let me say this. The focus today is on pharma and healthcare. But when we had our own internal discussions a few days ago, Debolina and Navneet and myself, we kind of discussed that perhaps it'll be a better idea if I focus on some of the recent changes in IP law in the dispute resolution field. Before I do that, very quickly, I'd like to just make 2 points, and they relate to the health field. I would say that the first point I want to make is that of late, I find that the generic players are kind of ganging up in a sort of way against the innovator companies. You can see that in pre-grant oppositions, in post-grant oppositions, in lawsuits, and sometimes making arguments which they know to be incorrect, sometimes weird. And that's leading sometimes to some real shocking judgments. And my view is that when we talk in the context of vaccine waiver, as Debolina very rightly said, that it is a very complex field. I'm reminded of some of the big pharma recently, for example, Eli Lilly for the drug baricitinib has given out as many as 8 voluntary licenses in order to make sure that baricitinib, which is a COVID drug for COVID use, can be freely available. So big pharma does that as well. That's only an illustration of what companies do. And the real point here is that, as Debolina also suggested, there is a need to do what we call in court an Order 23 Rule 3, where all the stakeholders are brought on the table and you ensure that everybody's interest is met, which means that if companies are putting genuine money into vaccine creation, then they need to recoup their investments. It goes without saying. So they have enough money for the next projects. And at the same time, availability is ensured. And what the government needs to do is to just get the stakeholders together and say, how are we going to work this out? Come out with a plan. And that, what we call in court as an Order 23 Rule 3, a settlement between parties, is a kind of a settlement, a memorandum that can be worked out to the satisfaction of everybody. And I think that might go a long way. Perhaps the chambers of commerce and industry could all get together, work with the government, and create a sufficiently large group of stakeholders who could work out these kind of issues. Now coming to what I had intended to talk to you about, there is a very fundamental change taking place in dispute resolution. To start with, you may have heard that the Intellectual Property Appellate Board was abolished by an act of parliament on the 4th of August this year, which means that literally thousands of cases, something like 3,000-4,000 cases, are being transferred to the Delhi, Mumbai, the Delhi High Court, the Bombay High Court, the Calcutta High Court, and the Madras High Court, and the Ahmedabad High Court. And there is already a lot of shortage of judges in the high courts. So this is going to put a tremendous pressure. In short, speed has to be the answer. Speed of disposal. For speed, we have the Commercial Courts Act, which came in, and the lifespan of litigation was shrunk from about 5 to 10 years to about 1 to 2 years. Dramatic changes, as the whole lawsuit was divided into 8 parts with mandatory maximum periods for each. If you miss the deadline, it immediately goes to the next phase and you lose the right for completing that task. Case management was introduced, where a judge can actually manage a case, allot time for arguments, allot time for cross-examinations, decide how many witnesses there will be. The appeals were limited, so not all orders are appealable to the High Court from a single judge to a division bench. You can only go to the Supreme Court, so the number of appeals were limited. There could be summary disposal, which means if the defendant has not said something substantial, you don't have to go to all the way to the end of evidence and final arguments, but the judge can summarily dispose of the matter in the plaintiff's favor, or vice versa, against the plaintiff if the plaintiff has not made out a case. Then evidence can be led virtually, which means if the witness is in the US or in any other foreign jurisdiction, the evidence can be led. Proceedings can be, recordal of evidence can take place outside the High Court premises, such as in a 5-star hotel, in the business center. You can, time-wise, you can conduct evidence over the weekends. Mediation, highly successful, which means you can, even without instituting a lawsuit, you can have pre-litigation mediation to resolve a dispute in total confidence. And return of the full court fees if you settle a matter. So there's tremendous encouragement to settle and conclude the hearing. And all this had happened. But after abolition of the IPAB, recently the Delhi High Court made the commercial division into an intellectual property division, which means a great signal that intellectual property matters will be given priority. And I think that is a very important fundamental message which has gone out, and hopefully that message would translate to higher quality decision-making and judgments. Now let me look a little on the substantive side rather than on the process. On the substantive side, let's look at patents. For standard essential patents in the telecom area, major disputes are taking place. The two recent concepts which have emerged are an anti-suit injunction, which effectively meant that companies, and this is typical, it happened in more than one cases, where a Chinese company sued by a telecom giant in India would file a lawsuit in China and prevent the movement of the lawsuit in India. And to make sure that that doesn't happen, an anti-suit injunction started getting granted by the Delhi High Court, which meant that the Delhi High Court really said, do not interfere with us. You can do what you're doing there, but do not interfere with our sovereignty and our right to administer justice. Also, confidentiality clubs. So in a lot of trade secrecy cases and standard essential patent cases, information has to be shared, documents have to be shown, which are confidential. And a confidentiality regime is set up where limited number of participants from both sides can see the documents, not the rest. And the structure of the confidentiality club came into question when one of the judgments of the Delhi High Court said that there cannot be a restriction If a confidential document has to be shown, it has to be shown to the defendants. You can't show it only to the lawyers or the external experts of the defendant, because he needs to defend himself. And a lot of the innovator telecom companies don't like that, because they have licenses with third parties which are highly confidential, and they want to protect that. Now, this issue is before the Supreme Court. It's a really hot issue at the moment. In pharma, you had the line of AstraZeneca decisions. First, the single judges, then in appeal, the division bench, which went one way and decided on issues of genus and species patents, effectively saying that something which is claimed in a genus and in a species patent is deemed to be disclosed in the genus, and therefore you cannot have a species patent, thus casting a doubt on the concept of selection patents. Currently likely to be appealed, the decision. There are decisions on the other side which have decided otherwise, and this is really a hot issue. Since I'm involved in a lot of these issues, I will not, and they are sub judice also, I would not like to speak very much more on that. Trademarks, comparative advertising has become really hot. Lots of cases in court on comparative advertising and intermediary liability, where Section 79 of the Information Technology Act always comes into question when companies say we are an intermediary and we are protected by this provision as a defense, and therefore even if somebody is selling fake goods on our website, it's not for us to monitor that. And if you bring it to our attention, we will stop and remove the link, but we can't do anything or monitor it on our own. We don't have the technology to do so. And the questions are, which have arisen now, is that in view of recent provisions in the law and in the some of the circulars of the Government of India, are there due diligence obligations on these intermediaries who want to take such a defense, and what do they oblige them to do? Those are a lot of cases are coming up in that field. On the copyright side, we have software cases going up, with a lot of cases now on phone home technologies, where companies monitor their software products through phone home technologies to find out if there are licensed versions, and using that data, they're able to go to court and stop the infringers. Also, in the music world, ISRA, the performers have a series of disputes currently where they are claiming that although they may have assigned to the producers of films their rights as a performer, but they cannot transfer one right, which is the right to receive royalties, because by legislation that's inalienable, that is, cannot be transferred. And if by mistake it was transferred, such an agreement is void, and therefore the collecting society of performers, known as ISRA, is able to collect on their behalf. So this is an issue where a lot of the big music companies have taken issue with the performers, and those cases are also pretty hot at the moment. These are some of the procedural and substantive recent changes that are taking place. I know I'm short of time, so I'll conclude at this point of time and say that I'll be here for question answers. Thank you very much.